Marcus gets pulled over in San Jose. Police find a small amount of drugs in the car. They arrest him, put him in the back of the patrol car, and start asking questions. No one reads him anything. No warning, no rights. He starts explaining because he thinks talking is going to help him. He just wants to provide his side of the story. And by the time a lawyer gets involved, Marcus has already made the job of the lawyer much harder. If you're wondering what happens in California when police ignore your Miranda rights, the answer is not what most people think. I'm Donna Knight. I'm a criminal defense attorney in San Jose, and in this video, I'm going to explain what Miranda actually protects, what it does not protect, and the exact words to use if you're questioned without a warning. So let's start with the biggest misconception. Most people believe that if the police forget to read you your rights, the whole case gets thrown out. That is almost never true. What Miranda actually does is protect your statements. If police question you in custody without giving you the Miranda warning, and you make statements, those statements could be suppressed, meaning a judge may exclude them from trial, but the arrest stays, the evidence stays, the charges stay. What goes away, potentially, is the damage you did to yourself by talking. And that is why the words you say matter so much. So here's what Miranda actually requires. Police must give you the Miranda warning before a custodial interrogation. A custodial means you are not free to leave. Interrogation means they're asking you questions designed to get a response or doing something the officer knows is reasonably likely to make you give a response or produce a response from you that incriminates you. If both of these conditions are met and they skip the warning, anything you say in response to their questions can be challenged later. But here's the thing. You do not fix a Miranda violation by hoping a judge catches it. You fix it by not talking in the first place. And here are the words. If police start asking questions and you have not been read or been advised of your rights, you say, I want to remain silent. I want to speak with my attorney before answering any questions. Say it once, say it clearly, and then stop talking. Your Fifth Amendment right to remain silent protects you. Your Miranda rights to have counsel present during questioning protects you. Invoking them is not an admission of guilt. It is the smartest thing you can do under the circumstances. Now, let me walk you through the most common scenarios where people get this wrong. Scenario number 1. Police ask questions before they arrest you. This is a trap. If you're not technically in custody, Miranda has not attached yet. Anything you say voluntarily before the arrest is fair game regardless of the warnings. That is why police officers often prefer to ask questions before they formally arrest you. The conversation feels very casual. You think you're just talking and everything you say is usable. The rule is simple. If police are asking you questions as part of an investigation, you do not have to answer. You are not required to help them build a case against you or help them get you convicted. You can say, I'm not going to answer questions. Am I free to go? Scenario number 2, you're in custody, you invoke your rights, but then you keep talking. Invoking Miranda only works if you actually stop. If you say, I want a lawyer, and then keep answering the questions, courts have found that you can undermine your own invocation or your assertion of your right to remain silent. So say it, but then be quiet. Don't talk after you invoke your right to silence. Every word after that is a risk. Police are trained to let the silence sit, to create awkward silences. The quiet is uncomfortable, and most people feel like they have to fill it. Do not fill the silence. Scenario number 3, Miranda is violated, but you still gave a confession. And here is where it gets complicated. Even if your Miranda rights were violated, courts look at whether the statements were otherwise voluntary. A Miranda violation does not automatically mean your statements are excluded if the prosecution can argue they were given without coercion. Your attorney will also look at whether any other constitutional violations occurred alongside the Miranda issue, and if the police conduct crossed into coercion, or if there were Fourth Amendment violations and how the evidence was gathered, there may be a broader grounds to suppress. That analysis is fact-specific and requires a careful review of the full sequence of the events and what you said, what actually transpired in the conversation, which is exactly why getting an attorney involved early matters and can change the outcome of your case. Scenario number 4. You're questioned in a police car, at a station, or after being told you cannot leave. All of these are likely custodial settings, and if you're not free to walk away and police are asking questions designed to elicit a response, Miranda should apply. If they skipped it, document everything you remember and tell your attorney immediately. Scenario number 5, the public safety exception. There's a narrow exception worth knowing about. In situations where police ask a question to protect immediate public safety, courts have allowed the resulting statement even without Miranda warnings. For example, asking where a gun is during an active threat situation. This exception is narrow and courts do not apply it broadly, but you should know that it exists because police sometimes use it as a justification to ask questions first and then sort out the legal analysis later. So what does suppression actually get you? If your attorney successfully argues that the police violated your Miranda rights and your statements are suppressed, those statements cannot be used as direct evidence against you at trial. Be careful though, because if you do decide to testify at trial, your statements, even if they were given in violation of Miranda, could be potentially usable to impeach your credibility. And in some cases, when your statements are suppressed because there's been a Miranda rights violation, that takes away the prosecution's best evidence. In other cases, it removes an admission that made a borderline case into an easy conviction. The value depends entirely on what you said. It depends on whether your statements led the police to discover additional evidence against you based on your statements. It gets pretty nuanced, and there's this idea of the fruits of the poisonous tree. A suppression motion is a tool, not a guaranteed outcome, but it is a real tool and is one of the first things a defense attorney evaluates after an arrest where questioning happened and you gave statements to the police. What to do if you think your rights were violated or ignored? First, stop answering questions the moment you realize you have not been warned and you are in custody. Second, tell your attorney everything you remember about the sequence, when the questioning started, what you were asked, what you said, when they actually formally arrested you, and what the officer said before and after your arrest. Third, document it as soon as you can. Write it down while the details are still fresh in your mind. The timeline matters in a suppression motion, and you need to be able to help your attorney by giving a timeline and the sequence of the events. And whatever you do, do not try to walk back what you said or change your story later, because the prosecutor will likely focus on the inconsistencies and use that against you. Getting counsel involved fast is critical, and here's the short version of what we just talked about. Miranda does not save you after the fact, your silence does. If you're in custody and police start asking questions, you can say, I want to remain silent and I want to speak with an attorney. Then stop. Do not explain, do not clarify, do not add, but just so you know, stop. Anything after those words is a gamble you do not need to take. It's very risky. Have you or someone you know ever been questioned by police without a Miranda warning? Drop a comment below and tell me what county this happened. Laws across California should be applied consistently, right? But how departments or police agencies handle these kinds of custodial interrogations does vary, and I do try to read every comment. And if you want to understand your rights during a traffic stop or at the door of your house, watch my other videos on this channel that cover those exact situations. And if you're facing a criminal case in San Jose or anywhere in Clara County, California, and you feel like something went wrong during questioning, you can contact our lawyers at Night Law at 408-877-6177. What you said and when you said it matters, and we can look at whether a suppression motion makes sense, and drop a comment if you have a question about your specific situation.